The podcasting technology of NORML is made possible by Red Aphid Interactive Media. More information at redaphid.com. And distributed by the National Organization for the Reform of Marijuana Laws in Washington, D.C. This is your daily audio stash, the growing truth about cannabis. Welcome to the most popular audio podcast regarding marijuana in all of America and all the world, featuring interviews with scientists, politicians, doctors, prohibition policy activists, regular cannabis consumers, musicians, and NORML staff and NORML's board of directors, along with music and comedy no other podcast can offer. You can always find out more about the show at our website, NORMLAudiostash.com. We're ending marijuana prohibition with education, one listener at a time. Welcome back to the Audio Stash. Today it is Tuesday, May 29th. I'm your host, Chris Goldstein. Take a moment to join us at NORML to end marijuana prohibition in America. Just visit NORML.org to get involved today. Folks, if you want to increase freedom right here in America, if you want to increase freedom for every single citizen of this country, we need to end marijuana prohibition. We have links to get involved on our website as well at NORMLAudiostash.com. We have a set of very important interviews for you today. We'll speak with Alan Hopper from the American Civil Liberties Union Drug Policy Reform Project about the recent ruling from a DEA administrative law judge regarding Professor Lyle Craker at the University of Massachusetts at Amherst. Professor Craker is seeking to grow research-grade medical marijuana for scientists and doctors. Currently, the only place that scientists can actually get research-grade marijuana is from the National Institute on Drug Abuse, and not too many people get access to that supply. So Alan Hopper's interview is coming up. Also on the show today, our Government at Work segment. We'll speak with Paul Armentano, NORML's senior policy analyst, about the different state legislative happenings around the country, and an important interview with NORML of Oklahoma's Norma Satt. Norma is working to get medical marijuana on the official party platform of the Oklahoma Democratic Party. That's something that happened in Michigan this year. The Michigan Democratic Party adopted medical marijuana as part of their party platform. That could happen in even more states, so stay tuned for that interview today. It's a short holiday week, but it's jam-packed with great marijuana law reform information right here on the Audio Stash. Make sure you tune in every day. Stash, we're going to catch up with an important story we've been covering for almost a year. The application request from Professor Lyle Craker at the University of Massachusetts at Amherst to grow research-grade medical marijuana. On May 15th, DEA Administrative Law Judge Mary Ellen Bittner issued her ruling on the application, a ruling that could move medical marijuana a small step closer to one day gaining FDA approval. Joining us today is the lead attorney in the case, Alan Hopper from the ACLU's Drug Policy Reform Project, based in California. We spoke with Alan at the ACLU last year about the case. Alan, welcome back here to the Audio Stash today.
Thanks, Chris. Happy to be here.
Wonderful to speak with you again, Alan. Now, the DEA administrative law judge found that Professor Craker's application was, quote, in the public interest, close quote. So, Alan, tell us more about this ruling.
Happy to, Chris. As you know from following the case, Judge Bittner, the administrative law judge for DEA, held extensive hearings last year. Over 9 days of testimony she took, hundreds of pages of legal briefing, even more hundreds of pages of documentary evidence, considered all of that, and issued a decision back in February, an 80-page decision, 87 pages, in which she ruled in Dr. Craker's favor and recommended that his license be granted. Now, on May 15th, what she did was basically reaffirm that decision after having given DEA lawyers one more opportunity to submit briefing to her to persuade her otherwise, but she was not persuaded otherwise, and she has affirmed her decision that she issued back in February and has transmitted that formally now to the deputy administrator for the DEA, who is tasked with making the final decision. So we are pleased that Judge Bittner has stuck to her guns and has affirmed her decision. And she, what was most significant, I think, Chris, about Judge Bittner's decision is that she acknowledged that NIDA, who currently has a monopoly on the supply of marijuana, has significant stockpiles of marijuana available for research. And yet she still found that the current supply is insufficient because she recognized that there have been numerous instances of legitimate researchers with FDA protocols fully approved, wanting to do research with medical marijuana, who have been denied access to NIDA's marijuana. So in finding that there was currently an insufficient supply, Judge Bittner was really condemning the current system under which NIDA's monopoly allows NIDA to deny access to marijuana to researchers even when they have FDA protocols and their research is clearly legitimate.
Also, Alan, I understand that this scenario with marijuana is quite different from other drugs, notably some very serious narcotics like cocaine and heroin. With those substances in particular, there are a number of private firms that contract to produce research-grade material for scientists and doctors.
That's correct, Chris. NIDA has set up this very unique system with marijuana that does not apply to any of the other scheduled drugs that are permitted for research purposes. Marijuana is the only drug for which the federal government, has a complete and total monopoly on the control and on the supply, even for research purposes, which really makes no sense at all. It really is just a reflection of the federal government's continued opposition to legitimate research with marijuana that could lead to the approval of marijuana by the FDA as a prescription medicine.
And what does this ruling mean for Professor Craker? How soon could he begin growing marijuana at the University of Massachusetts?
Well, unfortunately, Chris, what this probably means for Dr. Craker is yet further delay, because there is one final step now that needs to be taken in light of Judge Bittner's decision, which is that the Deputy Administrator of DEA now is required to issue her final determination. Now, Judge Bittner, the way the area of the law works, Judge Bittner's opinion and findings really are only, technically, are only a recommendation to the Deputy Administrator, who then issues a final decision to be published in the Federal Register. Now, in the normal course of events, in a situation where you have an administrative law proceeding with a judge who hears evidence and issues a decision, 99 times out of 100, the final decision by the agency will correspond with and will accept the findings of the administrative law judge. But as we know from past experience, because this is a highly politicized area and the federal government has been long opposed to research with medical marijuana, there's no guarantee that what the deputy administrator is going to do in this case is the right thing. So we are hopeful that she will do the right thing and believe that given Judge Bittner's well-reasoned decision, there's really no legal basis for her to do otherwise. And so what we fear is what we may see here is a delay as the administrator, hesitates and doesn't want to do what she's really compelled to do by the law and the facts in this case. But there is legal recourse for Dr. Craker in the event that the deputy administrator does in fact unreasonably delay a ruling here. The Court of Appeals for the D.C. Circuit, the Federal Court of Appeals, has jurisdiction to review any final decision that is issued by the deputy administrator in a case like this, but also has jurisdiction to review a claim brought by a applicant such as Dr. Craker that the DEA is just taking too long to render a decision. So this happened once before, similar case, Francis Young's decision with another administrative law judge who decided back in the late 80s that marijuana ought to be rescheduled from Schedule 1 to Schedule 2. And the DEA administrator sat on that decision for, I think, about 15 months before finally rejecting those recommendations. I think that it would be a huge mistake for the deputy administrator in this case to wait anywhere near that long before issuing her decision. There's already a history of delay in this case. A court that is reviewing this is going to look at that history of delay, and I think is going to look much less kindly on unreasonable delay by the deputy administrator in this case.
And Alan, what could this mean for the broader picture of the FDA looking at medical marijuana? Does this ruling give added weight and added precedent for that?
I think that it does, Chris. I mean, as you know, the ACLU, along with NORML, has long been supportive of the individual laws, state laws, allowing medical marijuana within the states that have done that. But really, that is it's an unsatisfactory way of dealing with what really is a national issue. That rather than have this patchwork of state laws that differ from state to state, what really ought to happen here is the FDA ought to consider the question for once and for all, put science above politics, and review the research and evaluate the safety and efficacy of marijuana as a medicine. We're confident that when the FDA is finally permitted to do that despite the highly politicized nature of this question, that the scientists at FDA, when presented with the unimpeachable evidence and research, are going to have no choice but to conclude that marijuana is safe and does have efficacy as a medicine. So we really do feel that the best way to deal with marijuana as a medicine and with this question is to let the FDA decide it. The FDA has been unable to even get to the question because the research necessary to present the question to the FDA has been blocked by virtue of this monopoly over the supply of marijuana. So we really do see this case as kind of breaking the log jam and allowing research finally to go forward, and we're confident that the end result of this will be FDA approval of marijuana as a medicine.
Now, Alan, not to do too much crystal ball looking here, but, as someone involved with this and who's worked on it, how long might it be before we see the FDA, the Food and Drug Administration, approve medical marijuana?
That's a really good question, Chris, and I've talked with some of the researchers involved in this effort at length about that, and it really is a tough question to answer, but I will say this. The length of time that people and advocates and doctors and researchers have been trying to get federal recognition of marijuana as a medicine, as you know, spans many, many years. And I think that by anyone's calculation, we really are nearing the very end of that battle. I do believe that even though the FDA approval process is a multi-year process, that once the federal monopoly over the supply of marijuana is removed, that research will begin immediately. There's already been marijuana is one of the most studied drugs, one of the most studied substances in the history of mankind and the history of medical science. So while there is still the very specific documented research that needs to take place in order to move marijuana through the FDA approval process, I think that will happen pretty quickly once this federal monopoly over this access to marijuana is removed. So I think within the next 5 to 7 years, you could see marijuana finally approved as a medicine by FDA.
Now, this year we saw the Ninth Circuit Court of Appeals rule against Angel Raich in her continued lawsuit. You know, she had taken the concept that medical marijuana for her represented it essentially a right to life, the right to seek a treatment that literally keeps her alive. So I have to ask, you know, Alan, there at the ACLU and even for you personally, do you view medical marijuana as a civil rights issue?
This really is one of the most important and pressing civil rights, civil liberties issue of our time. The ACLU is involved in this case, in Dr. Craker's case, because we firmly believe, as I know NORML does, that patients like Angel Raich ought to be able to get their medicine from a pharmacy just like everybody else. And we agree with Justice Breyer of the U.S. Supreme Court, who said in Angel Raich's case that medicine by regulation is preferable to medicine by referendum. And what he meant was it would be better to have marijuana reviewed by the FDA to determine its efficacy and safety as a medicine rather than have this patchwork of individual state laws that govern medical marijuana access. And so we do believe fundamentally that this is an important civil rights, civil liberties issue. We believe that the courts have been unwilling to recognize the human right, the due process fundamental right that exists to access marijuana as a medicine in cases like Angel's where it really is necessary to preserve health or life. We believe that because the courts have thus far been unwilling to recognize that fundamental constitutional right, that really FDA approval is the best route right now legally for us to take. But I will say this as well, Chris. The Ninth Circuit, as you pointed out, just recently again denied relief for Angel Raich. But that decision is very important. The court, while denying that there is at this point in time a recognized constitutional right to access marijuana as a medicine to preserve health and to preserve life, the court recognized that the legal right that we're talking about, the sort of conceptual way that this legal analysis works, is that the due process rights, fundamental rights under the Due Process Clause of the Constitution, evolve over time. It's this notion of an evolving society and a culture in which our mores evolve. And the court specifically said that while today there is not yet recognition of this legal right, the day may well come much sooner than anyone has ever anticipated. And I think that's very important, and I think it's correct. The way the due process right works, as in the Lawrence v. Texas case recently, where the Supreme Court recognized a fundamental constitutional right to adults consensually to engage in sexual relationships with each other in the privacy of their own homes and the privacy of their own bedrooms. That Supreme Court case directly overruled a case, Bowers v. Hardwick, that was issued 20 years previously. Now, during that 20-year period, the Constitution didn't change. What changed was our collective understanding and recognition of a fundamental right within this society and this culture. And what the Ninth Circuit said in Angel Raich's case is that medical marijuana is fast becoming that type of a recognized right in our culture and in our society, much quicker, much faster than anyone had ever anticipated. So I don't think that the door has been slammed shut completely on that type of constitutional claim. Importantly, I don't think that the door has been closed at all on several other related constitutional claims that Angel Raich's case did not present, but that other cases like the Medical Marijuana Collective in Santa Cruz, WHAM, currently in federal court, that case raises some different constitutional arguments that I think still do have some viability even in today's legal culture. But I think that the fastest way that we're going to be able to get protection for patients to be able to access their medicine just like anybody else is through the FDA's approval process, and that's why I think that Dr. Craker's case is so important.
Righto, Alan. This has been a very informative discussion here today, and I want to thank you again for joining us to discuss the case.
Thank you very much for asking me, Chris, to appear on your show. I admire the work that you and that NORML have been doing in support of medical marijuana patients for a very long time now, and I'm very happy to talk to you. Thanks.
Thank you again, Alan. Alan Hopper is the Senior Staff Attorney at the American Civil Liberties Union Drug Policy Reform Project and has been representing Professor Lyle Craker at the University of Massachusetts at Amherst in his DEA application to grow research-grade medical marijuana. More information about this case is available from the ACLU and MAPS, the Multidisciplinary Institute for Psychedelic Studies. We have links at normalaudiostash.com. Welcome to another installment of our Tuesday Government at Work segment here on the Audio Stash, where we follow all of the different state legislative reform efforts for marijuana taking place around the country. We have two guests for you today. We'll start with NORML Senior Policy Analyst Paul Armentano for a roundup of the happenings last week. Paul, welcome back to the Audio Stash today.
Thank you for having me, Chris.
Great to speak with you today, Paul. Again, this is the busiest state legislative reform season in memory happening right now. So tell us about some of the developments last week.
Well, last week was, once again, quite a busy week as far as statewide legislative marijuana law reform. Probably the most significant events were that the Connecticut House of Representatives, by quite a wide margin, passed legislation to enact medical marijuana law reform in that state that would protect patients who are using marijuana under the supervision of their physician. The bill now goes to the Senate, where they have about 2 or 3 weeks left in this session to try and move forward on this sort of legislation. Also in New England and Rhode Island, the House and Senate both last week reaffirmed legislation that would eliminate the sunset clause that currently exists in Rhode Island's one-year-old medical marijuana law. That law is actually set to expire by, I believe, the end of June, unless the legislature approves this language, and we are certainly hopeful that they will. The governor in Rhode Island has announced that he will go ahead and veto this language, but we believe that we have the votes in the House and the Senate to override his veto, and certainly we hope that that is done before the June 30th deadline so that patients are not stuck in a adverse predicament for 6 months until the legislature reconvenes next year.
And Paul, do you think that time sensitivity there plays for or against the issue in Rhode Island?
Well, I think the legislature clearly understands that they don't want patients to suffer unnecessarily. Clearly, the overwhelming majority of both Republicans and Democrats in Rhode Island support this legislation. It's unfortunate that the governor is willing to put politics before science on this matter, but certainly it does seem to be the intent of the legislature to have this legislation signed, sealed, and delivered before the end of June and before they break for their legislative recess.
Now, Tennessee did turn down the legislation there, but the bills did move rather quickly forward before that.
Well, Tennessee, the bills that were introduced, there was a House bill and a Senate bill to legalize the medical use of marijuana by qualified patients. The bill did have a couple of committee hearings, and it actually did pass a couple of subcommittees initially. Not surprisingly, the bills were voted down at the close of the session, but we are quite pleased with the progress that we made, and we do expect the legislature to form a special study committee that will convene this summer that will actually investigate these bills further, and that will certainly give them a much greater chance of making progress when the legislature reconvenes in 2008. Similarly, in Alabama, a state not known for its liberalism when it comes to drug law reform. They had hearings last week as well on a bill to legalize the medical use of marijuana. Those initial hearings went very well. There was no opposition that testified at the hearings, and in fact the chair of the hearing said publicly that he found the testimony to be very persuasive and that he was incredibly impressed with the quality of witnesses and the quality of their testimony. So it really shows that this issue is making progress, not just in certain regions or pockets of the United States, but really all across the United States. And we certainly hope to build on that in the forthcoming years.
And Paul, with all of the local activity there in New England and the race for U.S. president heating up already this summer, how much do you think the marijuana issue will come up as the politicians are out there shaking hands and kissing babies on the campaign trail?
Well, certainly when the candidates are in New Hampshire, this issue is going to come up. There are locals on the ground in New Hampshire who are making it a point during this primary season to be where the candidates are and to ask them publicly what their stance is on different aspects of marijuana law reform, not just the issue of medical marijuana, but other broader topics regarding decriminalization and the regulation of adult use as well. So I certainly think, at least during the primary season, when these folks are campaigning, they are going to have to go on the record and voice either their support or opposition for marijuana law reform.
So this is where these local state efforts, this is where those local efforts can really play into national politics.
Most certainly. And, as we've seen with a candidate like Bill Richardson from New Mexico, his support of medical marijuana at the state level in New Mexico is playing into his national presidential campaign.
And to round out here today, Paul, what should we be looking for in the future? And what should folks be particularly focused on this week on state legislative reforms?
Once again, I would encourage everybody to continue going to NORML's Take Action Center on our website so that they can read the latest of what actions are taking place at the state legislative level. And certainly if you reside in some of the states we're talking about, Rhode Island, for example, Connecticut, Vermont, I really, really urge those folks to go to NORML's webpage and either write their senators or in some cases write the governor and urge them to move forward and sign these bills that are coming or at this point are awaiting their signature on their desk.
Righto, Paul. Thank you again for taking time to speak with us today during our Government at Work segment.
No problem, Chris. Good to be here.
Thanks again, Paul. Paul Armentano is NORML's Senior Policy Analyst. We have links to NORML's Take Action Center on our website today at normalaudiostash.com. Stay tuned. We're going to speak with Norma Sapp from Oklahoma NORML coming up next. Next up today in our Government at Work segment, we're going to take a look at a very interesting development in the state of Oklahoma. Joining us is Norma Sapp, the director of Oklahoma NORML. We have links to him on our website today. Norma, welcome here to the Audio Stash.
Thank you for having me.
Great to speak with you today, Norma. Now, the Oklahoma Democratic Party may be taking the issue of medical marijuana as part of the official party platform. We saw the Michigan Democratic Party do that earlier this year, so tell us about what's happening with this there in Oklahoma.
Well, for probably about 17 years, I've been introducing the same resolution at the precinct level, and I never really followed through after that. I would just hand it over to somebody and hope that it happened, and then I decided if it's going to happen, I better get serious about this and figure out exactly what the process is. And so about 4 years ago or 6 years ago, I followed the process and called and made sure that everybody had seen it and asked questions and lobbied people to find out what their opinion was. And I found out that from my hands, from the precinct level, it goes to a resolutions committee. That committee decides what's going to stay in and what isn't, and then if it stays in, it goes on to a district level, your congressional level. And then it also has to go again through another process called the state convention. And so anyway, this time I got myself onto the resolution committee and made sure it made it out of the county precinct level. And then when it got to the district convention, I think that they just passed it wholesale because they didn't have time to argue about the resolutions. And so it made it out of that level and went on to the district convention. And at that place, we had kind of a change in philosophy over the last couple of years. We had been electing people to the local politics that were interested in national politics and national party stuff. And instead, this time, they decided to stay with grassroots people who had gotten out and proven themselves, had walked the precincts, had helped people get elected. People had, really proven themselves as Democrats. And so this time, when it got to the floor to be decided at the state convention, instead of putting it off till the end and doing elections first, somebody was smart enough to do a parliamentary move and have the resolutions come up first. And all these people who had carried this through from the precinct level decided that these are the wishes of the grassroots people. We need to make sure that all of these resolutions pass. And so the argument was on the floor, and they weren't going to get their elections until those resolutions passed. And it did. Now it has to go to the national convention. And, of course, there's, at least 13 states that already have those laws. And so I think it'll be quite a conversation when we get to the national convention.
Norma, you've worked very hard lobbying state legislators there. Tell us, how do elected officials feel about the issue of medical marijuana in Oklahoma?
Well, the ones that I have spoken to about it agree that we shouldn't be locking up sick people, but they don't want to stick their neck out because they're afraid of their constituents. What I really need here in this state is some money to do some polling so that they will trust their gut and go with it. I mean, you and I have seen the polls. It's all across America, even in Oklahoma, that 70+% of America believes that should be an issue between the doctor and the patient only. It shouldn't be about politics. And if people out there really realize that we are locking those people up in Oklahoma, I think that they would probably speak up. But, it's just really hard to keep it in the news and to educate everyone, because still today, I find people who say, oh, yeah, I can get a prescription for that at my doctor, because there was, at one point, 30 years ago, a way to do that, I guess. And so I don't know. And also, too, I've heard from people that said their doctor got it for them here in Oklahoma on an oncology floor. Their doctor purchased it for them. So, unless it affects you directly and you have direct knowledge of it, it's just not something that people go seeking the information about.
And Norma, what does a state political party like the Democrats there in Oklahoma taking this issue on as part of the official party platform mean for the topic? I mean, do all Democrats seeking office then support the idea or at least become aware of it?
Well, yes, they'll have to become aware of it. They do not have to agree with the things that are in the platform, and they don't have to run on those issues. If they don't, then we, the people who elect them, should hold their feet to the fire on that. We should say, we should go to their campaigns and we should say, this is something that's in our platform, and we want you to discuss this. We want you to run on this. And if they refuse to, then we shouldn't vote for them. But, yeah, it really doesn't do a lot. It just is kind of a statement that when this gets to the national convention and Oklahoma has spoken and put this in their party platform, I think it'll raise some eyebrows. Recently, Tom Cole, my congressman, held a town hall meeting, and I asked him about the issue, and he says, if Oklahoma did something like this, it would really raise some eyebrows in Congress. And I think he's right. We are what's called the buckle of the Bible Belt. If we can tear it loose here, we can get it done across the nation.
Well, Norma, this is very interesting. Thank you so much for joining us here today to talk about this, and I look forward to speaking with you again in the future as this moves forward.
Yes, thank you very much for calling and telling everybody about it.
Thanks very much again. Norma Sapp is the director of Oklahoma NORML and is working to have the Oklahoma Democratic Party adopt medical marijuana as part of the official party platform, something the Michigan Democrats approved earlier this year. We have links to Oklahoma NORML on our website at normalaudiostash.com. You've been listening to NORML's Daily Audio Stash, the growing truth about cannabis. Make sure you visit our website at normalaudiostash.com. That's NORMLAUDIOSTASH.com for more information about every day's show. I'm your host, Chris Goldstein. Thanks for listening today. See you at 4:20 tomorrow.